The Senate Committee on Criminal Justice will come to order. The clerk will please call the roll.
Senator Flores?
Present.
Senator Parker?
Present.
Senator Hinojosa?
Present.
Senator Huffman? Senator Miles?
Present.
Senator King? Senator Hagenbu?
Present.
A quorum is present.
A quorum is present. Members, the purpose of today's hearing is to take up and consider items related to AI child sexual abuse material, deep fakes, and affirmative defense. During the interim, Lieutenant Governor Patrick asked us to study how predators use deep fake technology and artificial intelligence to harm or exploit children. Our committee held an interim hearing taking testimony specifically addressed by the bills to be laid out before the committee this morning. During this hearing, it became clear that technology has allowed the creation of this material to be easier, quicker, and more prevalent than ever before. Technology, whether through AI or other programs, has enabled child predators to produce material that is obviously so offensive that I believe it has absolutely no redeeming value whatsoever. In fact, these materials are often used to groom and abuse children. While there is Supreme Court case law related to this topic, it is important to note that the Supreme Court first held that child pornography has no protections under the First Amendment in 1982 in New York versus Ferber. While there has been other case law on this issue, I believe the prohibitions in these bills fall within the constitutional bounds. 37 other states, both red and blue, have versions of AI child pornography laws on the books. These bills will move our state forward in continuing to aggressively pursue and prosecute those seeking to harm and abuse our children. While current law does prohibit AI-generated pornographic material of real children, the law does not speak to images of artificially created children. This material can be just as offensive and just as harmful and dangerous. As you all are aware, it is not uncommon for the law to have to catch up with technology. And all of the bills to be heard today are all focused on protecting children from predators, producers, promoters, and enablers of this offensive material. We've consulted with prosecutors who prosecute and handle these types of cases routinely, and one which you hear from today. So I would like to thank Lieutenant Governor Dan Patrick and other members of this committee and the Senate for their hard work in this package of legislation. It is the intent of the chair to lay out all 5 bills at once, recognize the authors to explain each one, entertain questions from the members, hear invited testimony, hear public testimony, and then we will vote on each bill. So if you intend to provide verbal testimony or would like to register a position on one or more bills, please register at one of the kiosks located behind the committee hearing room. Members, the chair now passes the gavel to Senator Parker, to Vice Chairman Parker, for the purpose of laying out Senate Bill 20.
Thank you, Mr. Chairman and members. We'll go ahead now and lay out SB 20 and recognize Senator Flores to explain his bill.
Thank you, Mr. Chairman. Members, Senate Bill 20 creates a new criminal offense related to obscene visual material. This bill reflects an effort to address the challenges posed by modern technology in the creation and distribution of harmful visual content, particularly concerning the protection of minors. The bill specifically targets visual depictions of minors in obscene activities, regardless of whether the depiction is of an actual child, a cartoon or animation, or an image created using artificial intelligence or other computer software. So the key provisions of this bill, members, is the creation of a new offense. So it adds section 43.235 to the Penal Code, which makes it an offense to knowingly possess, access with intent to view, or promote obscene visual material that appears to depict a child under 18 years of age engaging in certain activities. The offense will be classified as a state jail felony. However, it can be elevated to a third-degree felony if the person has prior conviction under this section or related sections of 43.23, 43.26, 43.261, or 43.262. It can further escalate to a second-degree felony if there are 2 or more prior convictions. If the conduct also constitutes an offense under another law, the actor may be prosecuted under this section or the other law, but not both. So with that is Senate Bill 20.
Well, thank you, Mr. Chairman, for laying out that good bill. I know it's an incredibly difficult topic to think about such monsters that could prey on our children like this and this kind of horrific images, but it's so important that we show leadership, and thank you for your leadership, Senator Flores, in bringing this bill forward. Members, are there questions at this time of Senator Flores about the bill? I might just comment for a moment, Mr. Chairman. I think in addition to the good work that your committee did here in the interim, the AI task force was blessed to co-chair during 2024, also focused a good bit of time and energy on this issue. And it is horrific how common this is becoming, that it is spreading, and that there are monsters that would prey on our children, whether or not they're real images or not. And I think in terms of critical items for this session, I don't think there's anything that could be higher on our list of priorities than protecting our children. So I just want to thank you for your leadership in laying it out, and look forward to continuing to move forward in the process.
Thank you. Thank you, Mr. Vice Chairman. So is he present? If we can note that Senator King and Senator Huffman have joined the committee. Good morning.
Good morning.
Senator Huffman, are you ready to lay out Senate Bill 1621?
I sure am.
The chair lays out Senate Bill 1621 and recognizes Senator Huffman to explain the bill.
Thank you. Okay, just let me get my glasses on. I'll be ready to go. Okay, members. This is Senate Bill 1621. Last session, I passed House Bill 2700, clarifying that the creation, distribution, and possession of computer-generated content is criminal by expanding the definition of visual material to include depictions of a recognizable likeness of a minor using deepfake technology, AI, or other computer software. After monitoring this legislation and the development of technology, which we all know is moving very quickly, it is clear that further modifications are needed to the child porn statute to maintain its effectiveness and usability as a tool for law enforcement and prosecutors. Senate Bill 1621 rewrites our current child pornography statute to account for the advances in AI-generated content. The bill also creates a new definition for a depiction of a child and a depiction of a computer-generated child. These definitions cover images of a real child that could have been modified by AI, and images that are entirely AI generated and are virtually indistinguishable as a child. Furthermore, under this bill, a person commits an offense if they intentionally or knowingly possess or view visual material that contains a visual depiction of a child engaging in sexual conduct and know or believe that the depiction is of an actual child younger than 18 years of age. The offense is a felony of the third degree if the depictions are of a real child, and a state jail felony if the depictions are of a computer-generated child. Additional enhancements are provided for prior convictions if a depicted child is under 10 years of age, and for increased quantities of the illicit material. This bill sends a clear message that the production and distribution of sexually explicit material involving children will not be tolerated, regardless of if it involves actual images of children or is merely computer generated. As technology advances, we must ensure that our laws are updated. I'm hoping this does it, but the way things are moving, we may be back in 2 years trying to update it again. So,
Thank you, Senator Huffman. Is there any questions from the members for Senator Huffman? No questions? No questions? Thank you. We'll move on to the next bill.
thank you, Senator.
The chair lays out Senate Bill 441 by Hinojosa to explain the bill. Senator Hinojosa, you're recognized to explain the bill.
Thank you, Mr. Chairman. That's dealing with civil liability, and it's kind of different in that this is a criminal justice committee. But as we all know, artificial intelligence has really grown and expanded and offers so many benefits to society. across the spectrum, from business to healthcare and so on. But there's always some bad actors that come in and take advantage and misuse artificial intelligence to harm people and to damage society as a whole. So the misuse of AI to create non-consensual intimate visual materials, often called deepfakes, has grown. Even reports indicating that 96% of deepfake videos online are pornographic, targeting women mostly. In 2023, cybersecurity researchers found that searches for deepfake pornography increased by 900% within 2 years. Victims face severe emotional and reputational harm, compounded by the lack of a clear legal remedies. The issues escalate when platforms hosting notification applications which use artificial intelligence to digitally undress photos without consent. Current laws fail to address these AI-specific harms adequately under present law. Senate Bill 441 builds on prior initiatives which criminalize non-consensual disclosure of intimate images that does not account for AI-generated content. The bill closes that gap by addressing the unique challenges of AI misuse in creating and distributing intimate visual materials. What this bill does, it amends Chapter 998B of the Civil Practice Remedy Code, which is the unlawful disclosure of promotional intimate visual materials, and expands the scope by defining that visual artificial intimate is defined as a computer-generated intimate content created or modified using artificial intelligence. Adds terms such as notification application, which is artificial design to create artificial intimate material, and social media platforms for clarity. These are not available under present law for a victim of AI and misuse of these platforms. But it provides for a way to a victim to be able to file a lawsuit for damages and holds individuals or entities liable for damage if they produce, solicit, disclose, or promote artificial intimate visual material without the depicted person's consent, intending to cause harm. Let me rephrase that. Holds individuals or entities liable for damages if they produce, solicit, disclose, or promote artificial intimate visual material without the depicted person's consent intending to cause harm. Makes website owners and payment processors liable if they facilitate the production or disclosure of non-consensual artificial intimate material and fail to remove such material within 72 hours of a removal request. It also provides for confidential identity, which allows the claimant to use pseudonyms and maintain confidentiality throughout the lawsuit process. It sets a 10-year statute of limitations for filing lawsuits, starting from when the victim discovers the material or turns 18. That's my presentation.
Members, any questions? Senator Huffman, you're recognized.
Senator Hinojosa, this is fabulous legislation, of course. But I'm looking at it and I'm wondering, like, do we have any guidance for someone who wanted to notify, the website that that they are making this request? Is there some kind of formal process? Because I'm thinking of someone who's in that situation, comes across this. Sometimes it's hard to figure out who to talk to. Do you think you thought about that? I'm just wondering if maybe there's someone here who knows more about how that would be done.
We have that on the bill, on Senate Bill 442, that provides for that type of protection. I don't see it here in this bill.
That's what I was looking for. Yeah.
And besides that issue, there's also, I guess, another issue dealing with third-party liability. As we move forward with the bill, besides that issue, we have that issue covered on Senate Bill 442, but not in 441. Right. And that's a very good point.
Right. Because, you can see a woman or a man, whoever it was, wanting to make a formal notice to have it withdrawn and so forth. But I think you would have to have some way to to formalize that process if you were going to proceed further with the lawsuit. Because, you know.
I agree.
Yeah, okay, well, I just point that out, you know, as we always say, sometimes we can make legislation a little bit better, but I think it's a great bill, but maybe we can work on an amendment or something, or for the floor or something to kind of help with that.
The other issue, I guess, deals with intermediary liability. This is an issue we've got to work through also to make sure we don't catch innocent people that are just using the internet.
Right,
Okay.
okay, I'm willing to work with you if you like, sir.
Thank you. And any other questions, members? We'll move on to the next bill. It'd be, the chair lays out Senate Bill 442 and recognize Senator Hinojosa to explain the bill.
Thank you, Mr. Chairman and members. Senate Bill 442 is like a companion bill to the Civil Liability Bill, Senate Bill 441. But this addresses the issue from the criminal side for prosecution of bad actors. There's been obviously a increase in deepfake media, which is driven by artificial intelligence and machine learning. These are images or videos that are digitally altered or fabricated to falsely depict someone engaging in actions or behaviors they did not consent to, often with harmful consequences to the victim. These manipulations, when used to create sexually explicit content without consent, and that's very important, one of the key issues, without consent, can have devastating effects on the individual depicted, including emotional trauma, reputational damage, and even personal safety. Existing laws fail to fully address the unique threat posed by deepfake media, as they do not specifically criminalize its production, distribution, or the context of intimate depictions. The bill seeks to strengthen the legal framework by establishing clear legal definitions, enhancing penalties, and ensuring consent is prioritized in the production and distribution of sexually explicit deepfake content. And what it does, it establishes a clear legal boundaries for consent. The bill ensures that deepfake media can only be legally produced or distributed if the person depicted has given explicit consent in writing, and that consent must be informed, voluntary, clearly stated, and in plain language. Consent also includes a description of the deepfake media and, if applicable, the intended audiovisual work. Producing or distributing deepfake media without consent is classified as a Class A misdemeanor with harsher penalties, felony of third degree for repeat offenders. It also eliminates offenses based on disclaimers or labels that claim that media is not authentic, emphasizing that these disclaimers do not mitigate the harm caused by the unlawful content. It also includes exceptions for certain lawful activities such as law enforcement practices, medical treatment, reporting unlawful activity, and legal proceedings, ensuring that such practices are not unfairly impacted by law.
Members, Senator King, you're recognized.
Thank you, Chairman, and Senator, this is a great bill again. Just had one question. The section C2, where it sets up the affirmative defenses for the things you just mentioned, lawful and common practice for law enforcement, reporting an unlawful activity or legal proceeding. I just kind of wonder if maybe those should be an exception to the offense instead of affirmative defenses, because usually the affirmative defense is raised after you've already been charged with a crime, but if it's an exception to the offense, then you can't be charged with a crime. And since, in reading this, I understand that you don't intend for them to be charged with a crime if they're reporting the activity, or if it's a legal proceeding and they're producing it as required by law. So that was my only question. I didn't know if it should be, instead of an affirmative defense, an exception to the offense. That's on page 3 of the bill, section C2.
I see. On, I guess, line 6, instead of affirmative defenses, you're suggesting there'll be an exception.
Exception to the offense.
Because, yeah.
You can't raise an affirmative defense unless you're charged with it. But if it's exception to the offense, you can't be charged with it.
I think it's a good point.
Yeah, just quick observation. Great bill, wonderful bill.
You know, I don't have any issues in drafting an amendment to address that issue because it does make sense. Because first, when a affirmative defense, you charge a person, where with an exception, you don't charge a person because it's covered by the exception in law.
Yeah, and if the chairs want to pass it out today, I think that'd be something easy to fix on the floor too, if you want to do it that way.
Okay.
Thank you.
I'd be amenable to that. Any more questions, members? More questions? So we're going to pause for just a moment so we can get Senator Middleton over here and to lay out his bill. And so we'll just pause for just a moment.
All right.
All right, members, we'll resume. The chair lays out Senate Bill 412 by Senator Middleton. Senator Parker sends up a committee substitute for SB 412, and Senator Middleton is recognized to explain the difference between committee substitute and the bill as filed.
Thank you, Chairman Flores, for your leadership on this, and Senator Hall as well. I know we all filed bills very similar to each other, and I know it's a priority of yours and of this committee and of the Senate, so thank you for your leadership on it. You know, protecting children from sexualization and obscene materials has to be priority of this legislature, and as a dad, 4 kids, 3 boys, 1 little girl, 3-year-old girl, Martha Ann, I would do anything to protect her from harm, right? And that's why we're here today. And that is one of our most sacred duties as legislators, is to protect children from harm. And increasing concern by parents has encouraged this call to action to close huge affirmative defense loopholes that allow harmful sexual material and sexual performance of a child. Senate Bill 412 clarifies that the only affirmative defense exceptions to the penal code for harmful material and sexual performance of a child are judicial or law enforcement officers performing their official duties. So that's that course and scope that we hear about a lot. Currently, the affirmative defenses to the crime of sale, distribution, or display of harmful material to minors and sexual performance of a child is overly broad and is not sufficient to ensure the protection of our children against the growing online harm imposed through the display of obscene content and sexual performance. A child's innocence should never be taken from them under the guise of educational, scientific, psychiatric, psychological, governmental, or legislative reasons. And child pornography, harmful and sexual materials, and sexual performance of a child are egregious crimes, and the current loopholes of prosecution are frankly so big you could drive a truck through them. Creating a clear and much more narrow affirmative defenses for harmful materials and sexual performance will save many of our children. Senate Bill 412 ensures that children are protected from sexualization and abusers can be prosecuted to the fullest extent of the law. And with that, I yield for questions.
Any questions for the author?
I do, Mr. Chairman, if I may.
Yes, recognize Senator Hinojosa.
I think it's always a good thing to try to narrow a definition to close loopholes. But as I read your committee substitute dealing with clarifying that it is a defense to prosecution if at the time of the offense the actor was judicial or law enforcement officer performing official duties. And I look, for example, at an earlier bill that was laid out by Chair Huffman, Senate Bill 1621, the definition for affirmative defense is a little bit broader than that, in that it talks about bona fide educational, medical, psychological, psychiatric, judicial law enforcement, or legislative purposes. And my concern is just with the educational part. And I don't know if anybody's been prosecuted yet, for supposedly disclosing pornography and for a teacher in the educational context. But how would you teach a student about anatomy without violating the law?
Right, so you have to go back to the definition of obscene materials here and review that. And it's harmful materials means those that have a dominant theme that appeal to the prurient interest in sex, nudity, or excretion, and is patently offensive to the prevailing standards of the adult community as a whole. Obviously, this is an adopted TEKS course, I guess, or curriculum, because we know, in our public schools, that TEKS, that curriculum, has to be approved by our State Board of Education, and I'm certain they're not going to violate the law in doing that, because that is currently the law, the affirmative defense for educational purposes. Of course, we're removing that, but then you also have to think about under what scenario, say under the sexual performance of a child, would it be okay for educational reasons to talk about bestiality, or sadomasochism. Well, why would that ever be okay, right? So there's no educational reason for that. And you think of these harms that are being perpetrated on our children, it really needs to be reserved to law enforcement and judicial reasons when they're running a sting. For example, that's why that's in there is, our law enforcement needs to be able to catch predators that are doing this. So we need to provide those exceptions because we know also sometimes there are district attorneys that are rogue that go after law enforcement. We saw that here in Travis County. Where
And I really understand the goal, and we want to avoid pornography and bestiality and all this. I mean, it's very damaging, harmful to students. My concern is that it's so broad that we're also covering legitimate educational purposes. That the teacher may be teaching anatomy for a class, that they will be classified and being charged with a crime without having an exception. Am I off on this issue? Just try to figure out where is the line drawn.
Well, I think the problem now is that it's too vague. It's a big gray area right now with the size of the affirmative defenses. And frankly, as lawmakers, I think when we're dealing with preventing harm from children, we shouldn't err on the side of the predator. We should err on the side of protecting the child. And I think the way that it is right now and how vague it is, the law is actually leaning on the side of basically the bad guys. And we're trying to make sure that we're going to lean on the side of being stricter and making sure that we're going to take these steps to protect our children. But like for the harmful material, you have to look at one of the provisions in 4324 that says whose dominant theme taken as a whole, right? So it's not necessarily a snapshot. So what you're talking about is more of an educational course that would occur in a public school, for example, anatomy or biology or something like that, where clearly, those have been adopted by elected officials, implemented by elected officials. And then we have a civil means too. Senator Paxton has Senate Bill 13 to come up with a civil way to remove some of these materials that maybe don't fit this, right? And that includes profane, right? This doesn't cover profanity. Senate Bill 13 does, so that's kind of a rung down on the ladder. But we need to make sure we provide these tools to law enforcement because, last year we had about 300 people arrested for it, but only about 60 had charges brought against them. And I think a lot of that reason is because of how vague these affirmative defenses are.
And I understand the vague part. I guess I'm trying to narrow the affirmative defense to being bona fide educational reasons, right? And try to keep it so broad that it's a huge net that you catch people, right. Teachers that may be innocent in terms of as it relates to teaching a course. This is my only point on that. I agree with the bill itself. I just have that needs to be tightened a little bit. Thank you.
Thank you, Senator.
Any other questions, members? With that, thank you.
Thank you.
Senator Middleton. So as Senator Parker had laid out, the committee substitute for Senate Bill 412. Are there any objections to this adoption of committee substitute Senate Bill 12? Senate Bill 412. Hearing none. Adopted. So the chair will now call up invited testimony. Be Brody Burks, Assistant Attorney General, Captain Stephen Stone, and Assistant District Attorney Lori Varnell. Thank you all for being here. Ms. Varnell, we'll begin with you.
Thank you. Thank you so much.
Am I right? And please.
First of all, I wanted to thank you all for having me this morning. The last time I was here, the committee discussed a multifaceted approach to combating CSAM or child sexual assault materials. And since that time, I was asked to help put together some bills.
Could you move the mic a little closer so
Yes,
we can?
there we go.
Thank you.
And Senate Bill 20 and Senate Bill 1621 that are before you are those bills. We needed to get rid of some conflict that we had in the enhancements and the child pornography statute. In addition to that, one of our objectives was to stop the influx of AI-generated child pornography. And so that is Senate Bill 20. And I'm here to speak in favor of both of the bills. My only one suggestion is in Senate Bill 20, there is in Section D, where it allows prosecution under other statutes. It may also qualify as obscenity or some other statute that might be a lesser offense. And what we'd like to do is instead of at the end of the sentence where it says but not both, you could say or both. So it can qualify under both offenses. That way, it gives us some leeway for a count 2 or something like that. And it also allows us to punish that conduct under 2 different sections and gives us the broadest ability in front of a jury. Wanted to just bring up the fact that this has been a long process, but one of the things that was so important in this process was that we also create the AI-generated child pornography prohibition inside the child pornography statute. So we've done that as well. That's one of those multifaceted approach. You also see the AI child pornography being punished under engaging in organized crime to stop would-be businesses with servers pumping out AI child pornography. And so we did that as well. And then the final things that we talked about last time, and I made notes because I wanted to make sure I got all 4 of them, was a change in the obscenity law, which we don't see here. A change in that obscenity law to make it unlawful to create AI child pornography that may be not qualifying as pornography, but maybe under the child erotica area, where something is obscene. And to keep that from going over with our children, we certainly don't want images of children engaged in obscenity. And so that's not done in Senate Bill 1621 or 20. So that is still out there to be reviewed. And then finally, I know that Senator King has an education a bill that he's put together that looked very good. But I'm just here to answer any questions that you have and why we went certain ways on these bills. But they look really good other than that one tiny little, not both, should say or both.
Senator Upton.
Yeah, could you clarify again what you're saying about what should be added to the obscenity statute? Because I wasn't following exactly how that would enhance prosecutorial abilities.
So one of the things that we spoke about last time was changing the obscenity statute, and we had some testimony regarding laws in other states related to obscenity. And so one of the things is as you go down the rung of child pornography, you get down into what would be an obscene action with a child. Not necessarily would it qualify under the child pornography statute, but as you're going down, what we've seen in children's books, as we've just heard about in school, is some obscene material that's in there. And so one of the things that we were going to address is changing the obscenity statute and changing actually the providing harmful materials to minors statute. We didn't do that in these bills. And so that's still out there to be done.
So can I ask you, how would you word something in the obscenity? I'm just curious because, as you know, that's a tricky statute, the obscenity statute, actually staying within constitutional grounds and so forth. So where would that nexus be where it wasn't a crime otherwise, but you would want to make it a crime by including it? I mean,
So,
what would the wording look like?
So one of the things that I authored is patently offensive representations or depictions of a child participating in masturbation excretory functions, which is not in the child pornography statute, sadism, masochism, lewd exhibition of the genitals of the male or female genitals in a discernibly turgid state, or a device designed and marketed as useful primarily for stimulation of the genital organs. And so that's some of the
You're telling
language.
me that would not be child pornography if that was depicted visually and it otherwise wouldn't? Well, I think we need to fix that.
Well, and I have an example, because a lot of people don't realize that the examples are out there.
Okay.
And generally, they're cartoons. Like, this is full of cartoons, but it has a child with a strap-on device.
Okay, well,
That's sort of what we're
that
getting.
sounds like an easy fix, actually, if we just added it to the, well, okay, somebody needs to do that.
And another thing that we talked about last time was a registration, making that, if you're putting that into our child's library, it's a registration offense.
Right.
And so those are some things we didn't get done, still out there to be done. So we've got more work to do,
Yeah.
but I really am happy with Senate Bill 20 and Senate Bill 1621. They're awesome.
Well,
And
we
I
can-
think we're
I'm sure-
glad about them.
Mr. Chairman, if it's germane to your bill, maybe someone could add an amendment or, I
could
mean,
look-
if you're willing, but, or whoever's bill it's germane to, if it is, you know.
Yes,
rather
whatever
than-
bill- yes, whatever bill is
Just a
germane
thought.
to, we'll look forward to working with you as we proceed.
For sure.
Thank you, thank you.
Thank you, Mayor.
Chairman Flores, Vice Chair Parker, committee members, thank you for your time. Oh, sorry. My name is Stephen Stone. I'm a captain with the Texas Department of Public Safety, and one of the supervisors of the unit that conducts cybercrime and digital forensics for the agency. I've reviewed all the bills, and I think there's a lot of good changes in here, but I'm open to any questions, welcome any questions that you might have of me.
Any questions? Senator Parker?
Thank you, Mr. Chairman. You know, from your perspective in law enforcement, you know, seeing that things are changing rapidly all the time in this space, do you think we're playing offense as best we possibly can at this point with what you're seeing? I mean, just giving the fact that you're seeing things change in the theater on a regular basis.
As was stated earlier, laws are always playing catch up. I do believe that the laws as drafted here are doing a good start on trying to bridge that gap and reduce that lag that we have. Historically, when it comes to child pornography or animated stuff or AI generated stuff, we've always had to identify an actual child. The laws as drafted here go a long way in reducing that hindrance. We no longer have to identify an actual child. If a reasonable person looks at that image and says, yep, that's a child, then we're able to take actions. So I think that does a lot, even with as fast as the technology is growing, that law enforcement will be able to take action when they run across this material.
Very good. I mean, look, with regard to all the things we need to talk about in terms of how to address AI and its rollout and regulation, there's nothing more important than this and protecting our children from all this predatory nonsense. So thank you very much.
Absolutely. Yes, sir.
Well, Senator Hagenbuth?
Thank you, Mr. Chairman. You know, these bills are very, very important to put into law. And thank you for all the work you all have done on it. But even harder, I think, is probably to enforce them. And more important, really, I mean, they're no value unless we can enforce them. Tell me about how you go about enforcing these laws. Seems like it can be a hard crime to identify. Maybe you get some, but I'm curious about what kind of percentages you think you get and how we can improve the level of enforcement.
With regard to AI-generated material, it's hard to give you a percentage because right now our tools are not very effective at identifying whether it's an AI-generated image or an actual image. So we will have to get some of those tools and some of that software to be able to help identify those. But furthermore, several of the bills are drafted in such a way where, because again, we don't have to identify it's an actual child, it allows us to take some action on it, the fact that a reasonable person would be able to look at it and identify it as a child. Historically, I guess it's not a good thing, but the good part about it, trying to enforce these things, is even if we find the AI-generated stuff, historically we find a lot of actual identified stuff, images and videos and whatnot. So that allows us to take action on those items and then just include this stuff as more evidence of the crime.
Could you just explain a little more basically to me, for education purposes, how what's the process for you enforcing or finding these predators or these offenders?
So there's several ways. We'll have outcries, or we'll do peer-to-peer type investigations where people are sharing files back and forth. We've had people report where they're in a public space and somebody's looking at something on their device and they'll notify law enforcement and we manage to show up before that person disappears. So there's a variety of different ways that we are notified of this. And then obviously once we're notified, we'll either confront that individual or get the appropriate legal process to search their computers, search their devices, and, determine what their online activity is.
Thank you. Appreciate it. Thank you, Mr. Chairman.
Senator Hinojosa.
Thank you, Mr. Chairman. One of the challenges we face is because artificial intelligence is changing so fast, so quick, is trying to define the different applications, define the different platforms by trying to provide definitions that are all encompassing. And as you read some of the legislation, it will be helpful to us if we are missing some definition to make sure that we don't leave or try to close any potential loopholes. Obviously, this is always changing area, so that will be helpful to us in identifying that. We have a definition of deep fake media, pretty much a definition of deep visual depiction. So, we try to provide definitions that encompass as much as possible. But you who are out there in the field, provide us some feedback when you read these bills, whether or not it really should be, we should have a modification or amendments or changes or expand it.
Yes, sir. The definitions that are in these bills, I think they're, as I see it right now, they're fairly all-encompassing. The only question I had or concern I had was in the 1621, when you get to the section, what is it? Sorry, multiple pages here. It is paren 2B and then 2. The law, it says a videotape or film that visually depicts conduct constituting an offense under section 22.011A2. That is the penal code that deals with sexual assaults. I am curious why it was limited to a videotape or film, when in today's society, the chances of us running across that are pretty slim. If it was also included to have digital files or digital video or something to that effect, it removes any ambiguity and allows us to take action on anything that we might find.
Okay.
Thank you.
Thank you.
Very good feedback.
Any other questions? Mr. Burks?
Thank you. Good morning, Chair Flores, Vice Chair Parker, senators of the committee. My name is Brody Burks. I'm a prosecutor with the Human Trafficking and Transnational Organized Crime Division of the Texas Attorney General's Office. Over my career, I've had the privilege to seek justice for victims of child exploitation that's often put my cases at the leading edge of technological exploitation. Prosecutors and law enforcement have seen the rapid digital development of child sexual abuse material, otherwise known as CSAM, and child pornography. This revolution started with Photoshop and other digital editing tools, but has reached new levels with the rise of generative AI. Senator Hinojosa, we see you talking about nudification apps, those kinds of things. Our investigations showed that these images are not being used only for the personal gratification of their creators, but to normalize child exploitation of children, groom them into compliance with behaviors that the abusers desire, and to extort them financially and sexually. A substantial part of my job is speaking with community groups on the risks and realities of trafficking and online child exploitation. In 2024, I personally delivered 42 trainings, and in nearly every single community I visited, I heard from parents about their children, both boys and girls, being subjected to online exploitation through sextortion, fake nude images, or other forms of sexual bullying enabled through digital tools. Attorney General Paxton is passionate about this issue and takes seriously the obligation to pursue justice for child victims. The staff of the Attorney General's office is dedicated to meeting all of these challenges and working to make sure that the criminal statutes reflect 21st century realities. The Senate bills on today's agenda make substantial strides in addressing both the how and the why of why children are at risk for sexual exploitation, and I'm happy to answer any questions that you have.
Any questions, members? So any other feedback from you all? And we appreciate you being here on and the expertise that you bring and the work that you've done for us in the interim on these bills as we continue to craft them in this process. And it's something that's of paramount importance to us and to the state in our effort to be as proactive as we can, not try to be as reactive, but certainly the people who make it work are those that in law enforcement and the prosecutors to keep us appraised on what you need, what are the tools you need to effectively address this very serious problem. So we thank you very much. So there'll be no additional testimony from invited witnesses. We thank you. Invited testimony is concluded.
Thank you all very much for everything you do. Thank you.
The chair now opens for public testimony, and the chair calls the following witnesses. And please identify yourself for the record, speak into the microphone, and limit your testimony to 2 minutes on each bill. So the chair now calls Zach Whiting, John Wilkerson, and Shannon Edmonds. Please proceed.
Good morning, Mr. Chairman and committee members. My name is John Wilkerson. I represent the Texas Municipal Police Association. We represent about 35,000 law enforcement officials throughout the state of Texas. I'm not going to take up too much of your time. You just heard a lot of good information. My main purpose of coming up here today was to talk about some of the things that we already talked about, but I'm going to forego that and just say thank you to this committee for taking on these serious matters, helping us protect Texas children. Our members are out there every day on that front line doing just that, and when they face prosecutorial issues, we're glad to see this committee taking up these very important matters and working so hard and diligently to correct the issues that we're seeing. So thank you.
Thank you.
Thank you, Mr. Chairman. My name is Zach Whiting. I'm Technology Policy Director at the Texas Public Policy Foundation. We are so grateful for all 5 bills that you have laid out today. The foundation is supportive of every single one of them. And to echo the point that my fellow witness just laid out is before I came to Texas, I was a state senator in Iowa, and I handled what I called the sex and death bills. It was these awful situations where someone would just do something horrible, rotten, and nasty, and the legislature would have to come in and fix them. And you all have done that. You've done that last session. You did it in the interim, and you're doing it now. But to just emphasize that point is the people that deal with this, not only the victims and survivors of this, but the folks in the forensic nursing space and law enforcement that handle these things. The problem is real. I think between the testimony that you've heard last session and the interim, the great witnesses that testified before, I think the issue that we've identified, it's real and it's serious, and what can and should lawmakers do about it? Act swiftly and strongly, and you are doing it with all 5 bills today. So thank you for bringing those forward, and we stand at the ready at the Texas Public Policy Foundation to help you all however we can. Thank you.
Thank you, Mr. Chairman and members. My name is Shannon Edmonds with the Texas District and County Attorneys Association. Just briefly, I registered on Senator Hinojosa's Senate Bill 442. I'm sorry, Senator King isn't here. I don't think you want to change your affirmative defense to an exception, and we can explain that offline, if that's okay, or when he's back. I'm happy to answer that question. I think you want to keep the bill the way it is to make sure it's prosecutable. Also, on Senate Bill 20, Lori Valnell already mentioned this, but there is probably a change needed that we just noticed last night or this morning to make sure prosecutors have the discretion to prosecute or allege multiple different offenses that may apply to this conduct, especially because As Senator Huffman pointed out, the technology is changing. If we're limited into only prosecuting one offense specifically, and the prosecutor chooses wrongly, that person goes free, even if they were guilty of other offenses that we could have alleged. And we're seeing this language that was put in by Legislative Counsel recently, and we don't know why. It started last session. We've always been allowed to prosecute under one or the other or both. But just last session in the child grooming law that passed as part of your trafficking bill, after it passed, we noticed the language says you can prosecute one or the other, but not both. And we don't know why you would want to limit prosecutors' options in going after these people you're trying to target. So we're going to try to keep a track of that in the future and let you know if we see that in drafts, but this might be a good one to start correcting that. Thank you.
I thank you for that, and of course, you're the ones who will prosecute it, and we want to make this something that is an effective tool for you to use to address this very heinous issue. And so we look forward to amendments. Senator Huffman.
Yeah, if I have a question for Shannon, do you need me to go back and fix that other one?
That's a good question.
Yeah, I'm happy to do it if you just get with my office.
And I just read an article that a prosecutor got a conviction under that offense, which may be the first one, and I was going to follow up with them because it would be an easy fix.
It'd be very easy, and I think that was my bill, and I assure you that we all overlook that because I wouldn't have ever, because I understand the implications of that. I also wanted to ask you, do you think it would be a good idea, agreeing with the invited DA, who is, I can't remember her name, to add that extra
or both
charge in the obscenity or way to commit obscenity in the obscenity statute? Were you here listening to her testimony?
I did catch part of it while I was talking to someone else. I'm not sure if everybody agrees that that's unprosecutable right now.
Yeah.
So it might deserve more discussion.
Okay, that's why I asked. Okay, we'll talk about it. Thank you. Thank you, Mr. Chairman.
Thank you, and thank you all very much. Senator Parker.
Thank you, Mr. Chairman. Shannon, thank you for being here. Just a question. In 20, we have the ability to increase the penalties on a reoccurring basis, right? If it's happened more than once, and there's a couple different mechanisms to ratchet it up. Earlier in the testimony that we heard, and it might have been from, I think it was from our friends from DPS in the earlier panel, that talked about often when you see this stuff that is computer generated, that at the same time it will lead you to seeing real babies that are being depicted. It's just unbelievable. The whole thing is just beyond, well, it's beyond comprehension of the monsters in our society like this. But my question is this. When you do, in fact, see that occurrence where you've got the fake, so to speak, AI generated, and now it's led you to the real, is there an opportunity there to, is that effectively an escalation? In other words, it's not one, it's twice. Or does the bill contemplate that being an increase to the penalty in your assessment?
So I would have to look to see what our stacking law provides currently, because generally when you have multiple offenses that a person is convicted of, but it's all in one trial, those sentences must all run concurrently. So you can get a 10-year, a 5-year, and an 8-year sentence, but they all run at the same time, so it's really the 10-year that counts. Y'all have allowed, in certain circumstances, judges the discretion to stack one sentence on top of the other. Since this being a new offense, I don't know that this would qualify for that. You might have to add it in.
So we could add a statement, an amendment that basically allows for stacking and the discretion of a judge.
You could do that, right. It's never mandatory, but it's discretionary with the judge to consider that. Prosecutors would argue it. So that's one thing you might be able to do. And again, this goes back to that question of the either or one or the other, but not both. This is exactly what we want to be able to do both. There may be conduct that meets this, but also might meet the other. We want to be able to prosecute for both. So there are a couple of different ways that we could
strengthen
look
it a little further, enhance
increasing. Yeah, and the good news is when these cases go to juries in Texas, we get to have jury trials, and like most other states, they usually like to max these folks out. So
good. Well, you definitely max these folks out. No question about that. All right. Very good. Thank you, Shannon.
Mr. Chairman.
Senator Hinojosa, you're recognized.
Thank you. I just on the issue on Senate Bill 442, where we provide an affirmative defense for prosecution for the production or distribution of a deepfake media, and you said that we should keep it that way and not provide as an exception. I mean, what is the difference to the prosecutor in able to file this type of case, how it would hinder or maybe create problems for the prosecution of this type of offense?
Sure, and I'll try to make it simple, but we literally have a chart that we can give you that shows the differences because it's very complicated. But an affirmative defense means that the defendant has to bring forth the information that establishes the defense. Whereas if you make it, and then if he does, the state still has the burden to disprove it beyond a reasonable doubt. But if you make it an exception, that means in every case, those 4 or 5 things that are listed there have to be disproven beyond a reasonable doubt in every case, even if they don't involve medical or law enforcement, or even if they don't involve reporting a crime. And some of that information is only going to be in the possession of the defendant, and he has a Fifth Amendment right not to turn that over to us. So it creates a catch-22 loop where we can't prove our case because we can't disprove all the exceptions you created. But if you leave it in affirmative defense, then they have to bring that forward. And the reality is that happens before trial. If they had a good reason for doing it, their lawyer's going to go to the prosecutor and say, no, here's why this happened, and everybody's going to say, oh yeah, okay, that's permissible under the law. But if it creates this, exceptions are very rare in criminal law. So that always kind of perks up my ears when I hear that. I think it'll work the way you have it designed.
Thank you.
Thank you. Thank you for coming.
Thank you all very much. Thank you all for the great testimony.
The chair now calls Ray Hunt, Brian Hawthorne, Heidi Ruiz, and Kristen Bentley. Thank you all for being here. We'll start on my right.
Good morning. My name is Sergeant Heidi Ruiz. I'm with Houston Police Department. I have been with HPD for a little over 31 years. I worked in our Juvenile Sex Crimes Division for 10 years. In that period of time, I worked 950 cases of sex abuse against children. I currently work in our Criminal Intelligence Division, and I've worked in the last 18 months, 16 first-degree felonies, possession of child pornography. I'm here to act as a resource for any questions you may have.
Well, thank you very much for being here.
My name is Ray Hunt. Thank you, Mr. Chairman, for having us. I'm with the Houston Police Officers Union, been a police officer 35 years, and the executive director of the HPOU, and that's the capacity I'm testifying today in. To quote the previous chairman, the bill appears to be in good shape. Why are you actually testifying? Well, I was asked by Senator Middleton to come in here and just explain why we as law enforcement believe that there needs to be an exception for affirmative defense to prosecution for police officers who are possessing this. I want to be very clear. This is only for those police officers who are actually working in the units where this is taking place. It's not a carte blanche for any other police officer. No reason for a patrol officer to have this in their car. No reason for a police officer to have this at home. This is only for those working in the internet crimes against children, et cetera. So that's why we appreciate that he left those two in there, judicial and the law enforcement. I have any questions, I'm here to answer them.
Thank you.
My name is Kristen Bentley. I'm the State Republican Executive Committee woman for Senate District 1, and I chaired the Texas GOP's legislative priority, Stop Sexualizing Texas Kids. I'm speaking on behalf of myself today, and I am strongly in favor of the committee substitute for SB 412. Thank you, Chairman, and thank you, committee members, for prioritizing this important legislation and for Senator Middleton's collaboration and due diligence in ensuring that the language is correct, that it removes all unnecessary affirmative defenses from 43.24, 25, and 26, leaving only a very narrow carve-out for law enforcement and judicial officers who have that difficult job of investigating and prosecuting these crimes against children. I travel the state speaking for the Republican Party of Texas on this legislative priority. And I have led this priority since 2022. I always ask two questions, the same questions. Is there ever a reason to give a child porn? Is there ever a reason to have a child perform sexually for an adult? And I always hear the same resounding answer, no. And yet Texas law says otherwise. Texas law allows the affirmative defenses that this bill responds to. This bill, SB 412, gives the resounding no that aligns with Texans. Texans have zero tolerance for pedophiles, and that must be reflected in our laws. That's the position of the Republican Party of Texas. It's clear in our platform, and we're grateful that for this committee substitute. Thank you.
Thank you for traveling and being here. Sheriff?
Chairman, thank you. I'm Brian Hawthorne. I'm the Sheriff of Chambers County, and I'm the Chairman of the Legislative Committee for the Sheriff's Association of Texas. Two things, and I'll be very brief. Senator earlier asked about how difficult the investigations are. So I think it's important, and many of you represent very rural counties. So if you're a sheriff and you only have a handful of officers, your deputies, you may have 10 deputies and maybe one detective or two. These investigations take countless hours, especially when you're dealing with computers and trying to get search warrants and all of those things that it takes to build these cases. It takes hours. So the easier that you can make them and the more difficult it is for them to commit the crime, and the easier for us to prosecute it or to investigate it, to bring it to the district attorney's office for prosecution, is paramount for the Sheriff's Association. We are not the Houston, the Dallases. We don't have these massive child crime units. All right, we're using the same detective that's handling the family disturbance case is also handling the sex crimes case. All right, and I will also tell you that we try to use a lot of female deputies on a lot of these sex crime cases with children. It is very difficult for sheriffs to recruit female, competent, hardworking, dig-in detectives and deputies. So it is really important for you all to make these simple and easy for us to investigate them and prosecute them. Secondly, the and/or on the prosecution from the DA side, extremely important to the sheriffs because it allows the prosecutor to have lots of options to get our jails moved. Because the bottom line is if the prosecutor is only given one option and the defendant doesn't want to do it, his defense attorney doesn't want to do a plea bargain, they hold it and they end up sitting in my jail for 1 or 2 years sometimes. When if there had been some other options, they may have taken a plea and they may already be sitting in the penitentiary and not sitting in my county jail or our county jails. And we have 243 of those jails. So the and/or for the prosecutors is extremely important. Thank you for the time, Chairman.
Any questions?
Thank you, Mr. Chairman. Thank you for the excellent testimony from all four of you. I wanted to ask Heidi, if you don't mind, a question from your unique vantage point, being in the field for all those years. You comment on the fact that you really worked 950 cases in 10 years.
Yes, sir.
In Harris County.
Yes.
And so you just realize those numbers and just how staggering and how horrific this problem is, the scale of it. I guess my real question to you is, knowing everything that you know, looking at all these bills, do you have all the tools at your disposal to go after the bad guys? I mean, that's beyond the scope of this legislation per se, but do you feel like you've got all the tools you need to go after these monsters that prey on our children?
I'm a member of our Internet Crimes Against Children in Harris County, and we have a fantastic ability to get the job done. But what you guys have put on the table for the state of Texas is fantastic. The problem wasn't getting better, it's getting worse, especially with technology. So the ultra focus that y'all have is fabulous, and HPD supports all of these bills. And thank you for considering the children of the state of Texas.
Well, thank you for being on the front lines and putting your life into this work to protect our children. So thank you for all you do. Thank
Senator
you.
Hagan, with you recognized.
Thank you, Chairman. Again, not exactly on the bills, but following up on Senator Parker's question there, and thank you for the sheriffs. We appreciate the sheriffs obviously greatly and want to make your jobs not any tougher than they already are or fill your jails anymore. We know that's a problem. And I suspected what you said, which is these are harder crimes and take a lot of effort to prove, I would imagine. And we appreciate all your work on that. One of the earlier panelists mentioned upgrading software. I just wonder whether we can use AI sort of on the good guy side, to be sophisticated enough to go through 900, that number of cases and somehow filter this out and make your jobs, make it quicker, faster, more efficient, be able to catch more of these folks. Is there, I guess I'm asking the same question kind of, is there technological things that we could do to help you, do the job easier, better, catch more people, I guess, more bad guys? Is there anything along those technologically we could use that you're aware of?
Senator, I'll answer that from a sheriff's perspective. The answer to that is yes, but that software and technology is very expensive, and the only people that can afford it are the Houstons and the Dallases and the DPS lab. And from a sheriff, so when you figure there's 254 counties, and we'll just say 190 of us are 50,000 or less in population, that software, most of it requires a subscription, and it is very costly. So the governor has been really good about doing some gang task force operations across the state, and those tags have a lot of software that they're now allowing the sheriffs to try and get some of their evidentiary information into them. So that is really helping. So I will tell you from a sheriff's perspective, the governor's tags have been wonderful because most of that software, the governor's office is buying it, where we're all having the ability to use it and access it. So, but the answer is yes, the software is out there. It's just very expensive.
Thank you.
Thank you. Any more questions? Thank you all for being here. Chair now calls Jennifer Fleck, Sarah Warbelow, Shannon Ayers, and Deborah Simmons. Thank you all for being here, and if you state your name, and we'll begin on
Thank you. Good morning. My name is Jennifer Fleck. I appreciate the committee substitute and Senator Middleton bringing it forward. This is the 4th legislative session that this bill has been filed. I know because I drafted the first one in 2019, the only session we ever got a hearing, and it was in the House. My bill was different, though. It eliminated all the affirmative defenses like other states have led. In 4324, it gives a legal, so this is not about possession. 4324, this is on Senate Bill 412, sorry. The statute 4324 and 4325 are not about possession. 4324 gives a legal justification for the sale, distribution, and exhibition of sexual material that the officer knows is harmful to a child, if we're carving out officers, okay? Are we okay with judges and police officers selling, distributing, and exhibiting sexual material that we all agree is harmful to a child? Please read the language carefully. Knowingly harming a child is never okay under any circumstances. The next section applies to 4325. Again, it's not about possessing anything. It applies to the sexual performance of a child. It says, knowing the character and content thereof, the content being a sexual performance of a child, an officer, that's your carve-out, an officer employs, authorizes, or induces a child to engage in sexual conduct or a sexual performance. Please read the language carefully. Just like it is not needed in a judicial or law enforcement setting. Thank you.
Thank you very much for being here. You may proceed. Thank you.
Thank you. My name is Sarah Warblow. I'm here to raise some concerns with SB 412 and exclusively that piece of legislation. As you all know, obscenity is not synonymous with pornography. Pornography is a form of obscenity, but obscenity encompasses a much wider range of materials. It's the reason why the Supreme Court established the Miller test in 1973, recognizing that there are materials that individuals would not only possess but also share in a variety of contexts, which may offend certain members of the community but would be appropriate. By carving out these educational standards, medical, psychology, as well as psychiatry and scientific, it is creating a dynamic in which a professor of art history would have to be concerned about their curriculum because they may have a 17-year-old in your class. There are many 17-year-olds who attend universities. There would be concerns about a psychiatrist who is working with a child who is a survivor of sexual assault and trauma because they have materials that in another context of people would view as obscene but are critical to helping that young person understand what has happened to them and to begin to recover from that trauma. You would have bookstores that would have to police teenagers and second guess what content is within a book. Because again, obscenity is not considered simply pornography, but rather a wide range of materials that some people would have objections to. This creates a situation in which we have individuals who are policing themselves outside of the context of pornography and removing from the public sphere materials that they would otherwise be sharing or distributing to young people because they have scientific value, because they have literary value.
Thank you. Thank you for your testimony. Please proceed.
My name is Deborah Simmons, and I am for Senate Bill 412. In the 1940s, Dr. Alfred Kinsey published two books, Sexual Behavior of the Human Male and the Human Female. To summarize, Kinsey informed the general public that children are sexual from birth, children are never harmed from any type of sexual activity, all sexual taboos and sex laws are routinely broken, therefore sex laws should be eliminated. The American Law Institute followed up in the 50s and 60s with using Kinsey's science to draft the model penal code. And as it moved across the country, courts were wrestling with definitions of obscenity and formulating obscenity tests influenced by Kinsey. Penal Code 4324 for the sale, distribution, or display of harmful materials to minors was originally passed in 1973 with Texas's adoption of the model penal code. Then on June 21st, 1973, the Supreme Court issued their ruling in Miller versus California, which established the well-known Miller test. During 77, 85, 2011 legislative sessions, Section 4325 was created, and then it was split to create today's 4325 and 4326, leaving 4326 to be the possession and leaving 4325 to be the performance. This is a cleanup bill for what has been characterized as creepy code. Every library pack categorizes this bill as criminalization of librarianship. Today, 4 states have exceptions for educational purposes. 34 states have either defenses or affirmative defenses. These were all passed during that American Law Institute Model Penal Code adoption. 5 states have repealed their defenses since 2019, while 7 states either never had defenses or repealed them before 2017. It has been 6 years since I testified for this bill. Since then, 15 bills have been filed in Texas to address this issue, and this session already shows more than 10 versions. Kinsey's reports have wreaked havoc on the American legal and justice system, as well as education. Texas should repeal all Kinsey-based laws, and let's start by repealing these defenses and cleaning up this code. Thank you.
Thank you. Thank you for your testimony.
Thank you. My name is Shannon Ayers. I'm the State Education Director for Citizens Defending Freedom, and I'm here speaking in favor of the committee substitute for SB 412. Imagine a teacher, coach, or librarian giving your child pornography, but that teacher being protected by the law. It's hard to believe that this is Texas, but it is.
Texas law says you can give porn to minors in certain instances, including for educational purposes. And school districts are using these exemptions to keep explicit, obscene materials in the hands of our children. I've personally sat in school board meetings where administrators, board members, and their lawyers smugly cite these educational exemptions to justify keeping materials they themselves say are harmful and obscene. In Lovejoy ISD, I watched as a board trustee, a lawyer, used these very loopholes to reassure the district that they were legally protected in providing materials they deemed harmful and obscene, and then listened to the district's legal counsel follow up with confirmation of both the educational and scientific exemptions. While federal law strictly prohibits distributing obscene content to minors, Texas has created a shield for institutions and predators over the protection of children. These aren't abstract legal technicalities. These are Texas children being exposed to obscene material and Texas school districts hiding behind these exemptions to provide it. I think there were 13 bills filed last session to remove these exemptions, and not one of them made it to committee. The time for action to repeal these affirmative defenses is now. Our children deserve better. They deserve protection. They deserve lawmakers who won't compromise their safety. Because when giving porn to a child is considered acceptable in the law under any circumstance, then the law itself has become obscene. Please vote to protect Texas kids by voting yes to SB 412. Thank you.
Thank you. Thank you all for your testimony. Any questions, members?
Thank you all for being here.
Thank
Greatly
you.
Appreciate it. Thank you.
The chair now calls Dennis London, Vanessa Savage, and Rhonda Miller. Mr. London, please proceed. State your name and you have 2 minutes.
Thank you, Chairman. My name is Dennis London. I'm one of the statewide leadership team members for Grassroots America, We the People. I'm speaking on behalf of Grassroots America and myself, and we are here in support of Senate Bill 412 and the committee substitute, because this removes a 50-year loophole that's enabled this content to be in our schools. And as all of you may be aware from previous testimonies, every one of your districts has this book in its libraries. And if anybody can tell me a good reason why this book is considered educational, I'll withdraw my testimony. You heard the historical context as to how this came into being. 1973 here in Texas. It was 43 states. 7 states did not begin with this because they saw the insanity that this could lead to. This loophole is being abused. The original intent may have been for science and education, but what is actually done is it's created a legal gray area where the perverts, the pedophiles, and the groomers have been hiding. And the explicit materials are defended by Section 43.24. The performance and the assignments are defended by 43.25. Did I say assignments? Yes. There have been teachers who have assigned their children, seventh graders, to actually go home and masturbate and journal on it and tell them what the class and everybody else, what they felt about it. So under the guise of education, this book and others are not it. They are porn. Now, it's not all teachers. Let me get that straight. I don't want to accuse all teachers of being in there. But what we have to do is we have to return the innocence to our children and restore the law to protect them, not those who prey upon them. Committee substitute Senate Bill 412 gives the law its teeth back and makes it perfectly clear that Texas will no longer be a safe haven for those wanting to exploit children under the guise of education. In the words of Dan Bongino, cutesy time is over.
Thank you.
Good morning, members of the committee. My name is Vanessa Savage, and I am thrilled to speak today in favor of Senate Bill 412. I am a pediatric nurse with 10 years of experience in caring for the safety, health, and well-being of children. My fight to protect children began when I blew the whistle last year, exposing how Texas Children's Hospital was secretly providing cross-sex hormones and puberty blockers to minors, and illegally billing Texas Medicaid for these procedures. That experience made one thing clear: if citizens don't stand up, our children will continue to be exploited and harmed. I'm also the president of Protecting Texas Children, and our organization strongly supports Senator Middleton's legislation because it further enshrines the mental, emotional, and psychological protection of children in the state of Texas. The Texas Penal Code currently contains a loophole in which obscene and harmful content can be shown to children in school without legal repercussions. Under the current law, the innocence of children is being exploited, their minds polluted by adults with an agenda, and this is unacceptable. Senate Bill 412 narrows the existing affirmative defense provisions, otherwise known as the loophole that schools use to avoid criminal liability, by removing references to scientific, educational, governmental, or medical purposes and replacing them with more specific justifications focused on bona fide judicial, law enforcement, or legislative purposes. The bottom line is this: there's never a good reason to allow pornography in public schools. Children are always the unwilling participants in progressive social experiments. Therefore, it is our responsibility to protect their innocence at all costs. Thank you.
Thank you.
Thank you.
Please proceed.
Good morning, committee. Mr. Chairman, thank you for allowing us to testify. My name is Rhonda Miller. I'm the CEO of Purple for Parents United. It was our organization that led the way in the state of Indiana that repealed the educational exemption for the defense to prosecution for pornography and obscenity. I'm also the one who led the way on defunding the Kinsey Institute that you've heard about a little bit ago. So I would like to read a couple things for you, and then I'll talk further. Eliminate all laws governing obscenity by calling them censorship in violation of free speech and free press. Break down cultural standards of morality by promoting pornography and obscenity in books, magazines, motion pictures, radio, and TV. Present homosexuality, degeneracy, and promiscuity as normal, natural, and healthy. For those of you who do not know, those are 3 of the 45 communist goals. We had a team member on our organization that took a look at the 5 big publishing companies that put out this propaganda for children, and they're all tied to the World Economic Forum and the United Nations, including the one that this gentleman pointed out a little bit ago. Let's talk about it. So what I would like to tell you is that based on Kinsey's crimes against children and what he did, this resource right here lays out how communists, humanists, and Marxists all use Kinsey science to change our entire culture and to target children in the meantime. It's all based on Kinsey's fraud and data that you heard about earlier, which leads us to this right here, a national pedophile network. You heard about people talking about pedophilia. This is what they're after, is to pervert children to think that it's acceptable to have sex with adults. That is what we're talking about, and that is, unfortunately, what our government for decades has been involved in. So this material that's being presented to children and oftentimes required reading, that is essentially what it's feeding into. So I want to thank you for hearing SB 12, and I strongly encourage you to pass this and protect Texas children once and for all.
Thank you for your testimony. Any questions, members? Yep. Senator Park.
Just want to tell you, I appreciate you all so much. We all do, being here and traveling and sharing your thoughts. It's critically important. So thank you all very much.
Chair calls John Wilkerson, Liz Case, and Bonnie Wallace.
Good morning, I'm Bonnie Wallace, and I'm here to speak in favor of SB 412. In case you didn't know it, there is very harmful content in school libraries all across Texas. I'm here today to tell you what very harmful content looks like. I'm going to read from a book called Dead End by Jason Myers. This book is prohibited to Texas prisoners, by the Texas Department of Criminal Justice. You'll soon understand why. What's harder to understand is why this content is allowed to Texas children. Page 18, that's what I do when you fall asleep after we're done fucking. Then she undid his pants,
Bill's in good shape if we can
pulled out.
not.
I understand,
offensive
Pete.
language in the committee.
I understand, but this is, if I, as an adult, cannot speak this to you as adults,
But there's-
so that we understand
Children on-
what our children are exposed to, this is the problem. Have you ever sucked a dick and swallowed the cum before? So I won't read anymore, but y'all have it. I hope that you read it because Pete's getting really red, and I understand because I'm getting red too. Here's the problem. These books, people argue that there's nothing obscene in our libraries. They are either deceivers or they're stupid. Because I have 961 books on my list. I've got books with QR codes that take you to sex shops and sex videos. I have a book that tells you to look up interviews with your favorite porn performers and go to the sites they recommend. What kind of sites would porn performers recommend? I'm afraid to even ask. This book also has a disclaimer on the publisher's page that says the authors and publisher expressly disclaim responsibility from any adverse effects which may result from the use of information contained in the book. They know what they're doing. There's very sick librarians, very sick writers, very sick publishers that put disclaimers and think that that will absolve them from responsibility of harming and raping our children. These books are not literary. They have no literary value, and they need to be removed. Thank you very much.
Thank you for your testimony.
Yes, sir.
Ms. Case?
Good morning. My name is Liz Case. I was an educator for over a decade, and it's interesting to me that if I had chosen to, I could have showed children in my classroom pornography. Had I taken that same literature across the street and showed that same thing to a child, that would have been a felony. So how is it that we think it's okay for me to show that pornography to a child in a classroom? That is insanity to me. It makes no sense. I have to tell you, I have learned more things about sexual performance and pervertedness since I came down to the Capitol, and when I decided to testify on the health curriculum for the State Board of Education. I am a grown woman who's been married twice and has 4 children, and I saw things and learned things that I had no business knowing and saw and cannot unsee. These are things, there is no way you can tell me that they have any kind of educational benefit. Now, Ms. Bentley talked about how these are priorities and they're in our platform for the Republican Party, and that is true. But I will tell you that these are just basic values of decent people, and they are held by people all across Texas. It's not a Republican or Democrat issue. This is a decency issue. We have people on both sides. Senator Hinojosa is a Democrat who's writing bills. People care about protecting children. I appreciate this bill and appreciate the committee's hard work on this issue
Thank you.
to protect
Thank you for your
kids.
testimony.
Thank you so much. Thank you for being here.
Any questions, members?
Mr. Chairman.
Yes, Senator Higginbotham.
Just wanted to mention briefly that you can go ahead. Go ahead. I appreciate the passion these folks all have, and these bills are so important. They've made that even more clear to me today. To people in teaching profession, law enforcement probably seen even worse things. I just don't feel that being indecent helps us make the case against being indecent. And I don't mean to point anybody out, but I just think we need any more of that.
I agree. I agree. This is the Senate, and we want to hear people's opinions, but we have to keep things civil, and we will continue to press that issue more. Thank you for your comments. So is there anyone else that would like to testify for, on, or against Senate Bill 20, Senate Bill 1621, the committee substitute for Senate Bill 412, Senate Bill 441, or Senate Bill 442? Hearing none, public testimony is closed. The committee will now vote. Members are ready to vote? Okay. Senator Parker moves that Senate Bill 20 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Senator Flores?
Aye.
Senator Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator King? Senator Hagenbu?
Aye.
6 ayes and 1 not present. It is passed.
There being 6 ayes and 1 present but not voting, the Senate bill will be reported to the full Senate with a favorable recommendation.
Senator King. Senator King.
Present. Present, but strike the last comment.
Present, yes.
Senator Huffman moves that Senate Bill 1621 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Senator Flores?
Aye.
Senator Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator Hagenbu?
Aye.
Being 6 ayes and 1 not voting.
There'd be six ayes, 1 present. The Senate Bill 1621 will be reported to the full Senate with a favorable recommendation. So, Senator Hinojosa moves the adoption of committee substitute for Senate Bill 412 that be reported to the full Senate with recommendation to do pass favorably be printed. The clerk will call the roll.
Senator Flores?
Aye.
Senator Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator Hagenbu?
Aye.
6 ayes and no nays.
6 ayes, no nays. There being 6 ayes and no nays, the committee substitute for Senate Bill 412 is reported favorably to the full Senate. Senator Hinojosa moves that Senate Bill 441 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Senator Flores?
Aye.
Senator Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles? Senator Hagenbu?
Aye.
6 ayes and no nays.
6 ayes, no nays. Senate Bill 441 will be reported to the full Senate with a favorable recommendation. Senator Hagenbooth moves that Senate Bill 442 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Senator Flores?
Aye.
Senator Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Senator Miles? Senator Hagenbu?
Aye.
6 ayes and no nays.
6 ayes, no nays. Senate Bill 442 will be reported to the full Senate with a favorable recommendation. So members, is there any other business to come before the committee? Hearing none, Senator Parker moves that the committee stand in recess subject to the call of the chair. Thank you, members.
Thank you, Mr. Chairman.
For clarification, Senator King was present at all of these.